Thanks so much, everybody. Today, I'm going to talk on a very high level about intellectual property and the different types of intellectual property that businesses run into. Let's see if I go. There we go. I just have to push a little harder on the back. Just so you know, this series was originally going to be or this class was going to be taught by my partner, Pat Kelly, who unfortunately can't be here today, so I'm filling in his place. So please forgive me if I have to fumble through some of these slides. They're his presentation, so I'll do the best I can to work with his format. Okay, so intellectual property. There are 4 main areas of intellectual property that businesses run into. They are copyrights, trademarks, trade secrets, and patents. Just about everything that you will run into will fall into one of these 4 categories, and while they each have their own distinct areas that they provide proprietary rights to a individual or a business, there is some overlap as well, and we'll talk about those as we go along. So, copyrights. Copyrights relate to original works of authorship where the original work is fixed in some form of tangible medium of expression. Okay? The way to think about this is it relates to something that is more artistic or design-oriented, and what you are actually protecting has to actually be recorded or printed on something. Okay, that's the tangible medium of expression. If you're talking about a song, all right, what you are copywriting is actually the recording of that song. Okay, if it's a story, it's the written script of that story. All right, so it has to be fixed in a tangible medium of expression. To qualify for a copyright, it has to have originality. Okay, the work of art has to have originality. There's only a minimum level of creativity that's required, okay, for something to be copyrightable. There's a famous case, without going into too much detail, where it was found that someone had copyrightable subject matter simply in the list and ordering of people in a phone book or a catalog. Okay, it was a little different than just standard alphabetical order. They listed it in a different way. That was deemed a minimum amount of creativity to be copyrightable, just in the way that they organized their lists. So, bottom line here is you don't need a whole lot. You can use other people's works in the formation of your copyright, or whatever is copyrightable. However, you have to be careful because in many cases that becomes what's called a derivative work. So if you are creating something that necessarily involves someone else's copyrightable subject matter, you would potentially have some infringement issues relating to the practice of your own copyright, but in general you are allowed to create your own copyrights based off of derivations of other people's work. Okay, so here's a list of what kind of things are copyrightable. They include things, works of literary, music, dramatic, pictorial works, motion pictures, sound recordings, architectural works, sculptural works. Software is also copyrightable, okay, the actual code that you're writing. However, the protection there is pretty thin, but it is available. The key in copyrights, when you're deciding what is protected under a copyright, it is that artistic expression. Think of it that way, that is being copyrighted. It is not the underlying idea or concept, okay? Those ideas or concepts will fall under other types of intellectual property besides copyrights. So if you have, like for instance, let's say you make a jeweled beetle, like a pin, okay? And you can get a copyright for that. However, you don't have a copyright to the idea of jeweled pins looking like a beetle, okay? So there's just a distinction between the idea underlying the artistic expression and then the actual artistic expression itself. The artistic expression itself is what's copyrightable. Just going to jump down to the bottom of this slide. Copyrights last for a really long time. Okay? They last for the author, the creator of the work. The copyright lasts for as long as that person is alive, plus another 70 years. Okay? If you're a business and you own it, it's the shorter of 95 years after the first publication, or 120 years after creation. Bottom line is, it lasts a really, really long time. One of the biggest issues that comes up in copyrights is what's called the fair use exception. Fair use exception is basically this. It's a permission, it's a legal permission to infringe somebody else's copyright. Okay? The act that you're doing, if you are claiming fair use, is going to be considered an infringement. However, it's permissible. Okay? Fair use can occur in several different areas. The one that we see it most often, especially as an academic institution, any use of someone else's copyrighted subject matter for purposes of lecturing, for handouts, things like that, those are all under the fair use exception. There are some others, for example, some basic distribution amongst your family members, things like that, that you can also have fair use exceptions for. The bottom line, though, if you're not sure whether or not what you're doing is deemed a permission under the fair use exception, take a look and see whether the person who owns the copyright, okay, is the copyright owner somehow being diluted in his ability to enjoy that copyright in the marketplace. Okay, so if you are doing something where you are actually making money, all right, you are profiting either directly or indirectly off of someone else's copyright, you're probably not going to fall under the fair use exception. Okay, same thing is also true. Maybe you're not, maybe you're trying to do something for the good of everybody, but you're doing such a broad distribution, even though you're not personally profiting from it, if you are significantly diluting the copyright owner's market, that could also be outside of fair use. Okay, so be very careful when you are doing something that involves copying, and whether or not you are permissible, whether it's permissible to do that. Okay, going to switch to trademarks. Trademarks, this is here the trademark is for Gatorade. A trademark is used as a source identifier, okay, for goods and services that the trademark is associated with. In other words, the idea here is when you are putting a product out or you're performing a service, you're going to use your trademark as a way of telling the public who it is that is providing that good or service. Okay? And the hope here is for the public to see the goodwill that the business or individual is promoting in those goods or services. For example, there's a very famous trademark of McDonald's. You know, you get the big golden arches, right? You know, when you go into a restaurant that has the golden arches on it, you know that it means McDonald's Corporation, and it means you know what you're going to, you know what to expect. There's a certain level of quality. We can all debate whether that's good or bad, but we know what it is, right, when it comes to McDonald's. You know what you're going to get. So there's a reliance and some goodwill associated with that company for the association of the trademark in that set of goods and services. Trademarks are protected under both state law and federal law. There's actually a state registration system, although most people don't really use it anymore. Most protection of trademarks under state law really falls under common law doctrines, which I'm not going to really get into here, but what it ultimately boils down to, how are you using a unregistered trademark in commerce in the area, in the geographical area that you're in, and what kind of rights do you have based on that actual use. What most people do today is they register their trademarks with the United States Patent and Trademark Office. The reason they do that is because it's much simpler and it applies to all of the United States. The trademark that you get through the U.S. Patent and Trademark Office is renewable. Okay, if you remember, I said copyrights last for a long time, many, many decades. When that expires for copyrights, it's over. It's that artistic expression is available to the public. All right, it's owned by the public. For trademarks, the use of a particular trademark, once you're registered for it, is renewable for as long as you continue to use that trademark in commerce. Okay? So if you have a business and you are establishing the goodwill of your business through the use of your trademark, you keep doing that, you can continue to renew it every 10 years just by demonstration to the Patent and Trademark Office that yes, I'm using it, you provide evidence of that use, and they say great, you can maintain your registration. And that can go on indefinitely as long as you are actually using it. Okay? The minute your business decides to stop using it, you would lose the ability to renew that trademark. All right? Someone else could step in and get it. So, kinds of things that you see that are trademarked. You'll see words, okay? Either a single word or a short phrase. Sometimes you'll see, like a tagline or a slogan will be trademarked. So you can trademark the words. You can trademark symbols, okay, or designs. If you think about the Gatorade image that I showed right at first, there was a combination of words and designs. Okay? So any combination of words, designs. You can also trademark sounds, and you can even trademark the use of just a particular color. Okay? The key for any trademark registration is not just the symbol or word or whatever it is that you're using as the trademark, but it's the association of it with particular goods and services. Okay? An example of this is Apple computer, right? You get the little symbol of Apple. They use that in association with computers or with mobile phones. Okay? They do not have the right to control the use of the Apple symbol with laundry detergent. All right? If someone wants to come in and use the symbol Apple for their brand new laundry detergent, the company, Apple Computer, would not be able to stop them from doing that. So what's the reason of that? The reason is because trademarks, like I said, are a source identifier, and you want to be able to keep the public, you want the public to understand who the source is of any goods and services. If there's no confusion from a consumer about who the source is of that product, it's not a problem. Everyone knows that Apple Computer doesn't sell laundry detergent. So if another company comes in and is doing that, that's going to be okay because the consumers are not confused about who's who. All right? when you start getting trademarks that are starting to look kind of similar, right, and they are also similar in the goods and services that those marks are being used with or associated with, now you're going to have some problems because as a consumer, you're not sure. You're not sure who's who, all right? I can skip through these. Key to remember with trademarks, especially as your business expands, trademarks protection, when you file and register with the United States Patent and Trademark Office, it's going to be effective only in the United States. Okay, it doesn't protect you in other countries. All right, so to the extent that you have a marketing platform that involves foreign countries, you're going to need to go register your trademark in whatever country you think it's worthwhile registering in. Okay, so things, if you're going to be selling a product or a service in another country, maybe you're going to have some manufacturing going on in another country. Whatever it is that you think you're going to use your trademark, that should be a country to consider registration. All right. How am I doing on time here?
Good.
Okay, great. Trade secrets. Trade secrets are the opposite, at least I view these. These are the opposite of patents, okay? The goal of a trade secret is to protect your idea, your process, whatever it is that you think of value, and you keep it, you seclude it, you keep it secret from the public, all right? And you get to enjoy that secret for as long as you are capable of keeping it secret. All right, I say this is the opposite of patents because when you see, when we talk about patents in a few minutes, the whole point of a patent is to teach the public exactly how to make and use your invention, okay? And then you get a benefit of exclusivity for a certain period of time, but it's all based, the giving that you do in a patent is the public disclosure of your invention. Trade secret's the opposite, okay? You can enjoy a trade secret as long as you can keep it secret. Okay, so two things that you have to have for a trade secret. The information that you deem to be secret has to provide the owner with some kind of competitive advantage in the marketplace. All right, in other words, the business owner or individual has to believe that whatever it is that they're keeping secret has value to them. Okay, it can be subjective. All right, but as long as it has some form of value, it would qualify as a trade secret. And then the owner of that secret has to treat that information in a way that is reasonably expected to prevent the public or competitors from learning about the information, okay, absent theft or fraud or something like that, okay? So a business has to act in a way that is protective of their secret. They can't call something a trade secret and, just start publishing things online, right? You can't take your secret formula for your Gatorade drink, for example, and tell everyone how to make it. That's not keeping something secret. Internally, you have to have processes in place. You have to be using, you have to have your employees or anyone inside your business who's exposed to these secrets sign forms saying that they agree to keep it secret and that they will not share it with anyone outside of the company. Those types of things. So you put those measures in place such that in the event like for example, if an employee, let's say you have a key employee who holds a lot of secrets and your competitor finds this guy in the coffee shop and says, hey, I'll pay you $30,000 more a year if you come work for me. The guy says, that sounds awesome, I'll do it. So he goes over. If he goes and then shares the secrets that he was held or was required to keep confidential, he could be sued for breach of a trade secret. Which, by the way, just so you guys know, trade secrets are handled on a state level and they actually have criminal punishments related to them. You can actually go to jail for breaking trade secrets. Okay? It's different than some of the others, other rights such as patents and trademarks and copyrights. If you do things that are wrong, infringement actions, you'll get slapped with fines. Sometimes you can get slapped with punitive damages in those fines, but ultimately it's about money. You're not going to go spend time in jail. Trade secrets you can. Okay? I think one of the things that is key to understand with trade secrets, and people, I deal with clients all the time with this question. Like we said, trade secrets only are so good as keeping them secret. If you have a product, let's say like a black box product, okay, and you are putting that out on the market, if someone has the ability, if someone could buy that from you, legally own it, and then reverse engineer your product, figure it out, and figure out how it's made, they have every right to do that. And then they can compete with you from everything that they learn from your product that you put out in the public. Okay? Reverse engineering is not protected by trade secrets. So when you are debating as a company, do I want to keep something as a trade secret or do I want to try to get a patent for it? Think about that. All right? When you go and put your product in the marketplace, you have to decide, is this something that is easily reverse engineered? If the answer is yes, trade secret's probably not worth your time. Patents would make much more sense. Okay? If it's something that you think would be very hard to get through, or there's a huge barrier that would be required of your competitors to overcome in order to figure out how you do what you do, maybe trade secret is a good idea. Okay? This is just a list of some things that people typically or protect with trade secrets. Things like formulations, you know, the famous Coca-Cola trade secret, right? Patterns, devices, some ideas or processes, compilations of information, even like customer lists, okay, can be considered trade secrets. And again, there's no need for any sort of originality or novelty with your secret. It just has to be deemed valuable to you. This we talked about. These are more of the same thing. Another one that comes up that's interesting is negative know-how. You know, there's a lot of types of businesses that just the knowledge of what doesn't work can be of huge value to a competitor or somebody who wants to enter into a market. So, you know, it doesn't have to be a positive concept that you are protecting. It can be a negative knowledge base as well. Okay. All right, let's shift to patents. So, as I was just referring to, sort of as an opposite to trademarks, patents relate to a temporary protection of your invention. The give and take in a patent is you are donating the knowledge to the public of what you've invented. You have to teach somebody how to make and use your invention. Okay? If you don't actually teach them, if you're not accurately describing and show someone the best way to make and use your invention at the time that you file your patent application, it will be deemed invalid. Okay? It's supposed to be a genuine donation of that information to the public. And in exchange for that, if it is deemed a grantable patent, meaning that you can gain exclusive rights to whatever it is that you've claimed, you will receive that and you get that ability to exclude people for a certain period of time. The United States, one of the reasons why the United States is so strong from an intellectual property standpoint, and just historically, innovation in the United States just far outweighs anything that has ever been seen in any other country. the reason is really because of the patenting system. If you think about it, trade secrets force the knowledge base of the public down, right? People can't learn from each other when you have trade secrets. When you increase the knowledge base like you do in a patent system, you are allowing the public to look and see what you're doing and say, how can I make that better? Okay? You're teaching, you're elevating the level of knowledge in the public, and it really just escalates how fast a society can grow technologically by this patent system. Okay. So there are a couple different types of patent applications or patents that you can get. The standard one that everyone thinks of is called a utility patent. This relates to inventions that are processes, machines, methods of manufacture, compositions of matter, that kind of thing. There is another type of patent called a design patent. This relates to simply the ornamental features of some design, okay? It's not the, if there is functionality that is integrated into the design, it wouldn't qualify for a design patent. It just has to be ornamental, meaning you could make the same thing in a different design. If you can do that so that functionality can reside in multiple designs, you'd be fine. You could pursue a design patent. An example of something that would fit under a design patent would be like the shape of a Coca-Cola bottle. Okay? You can make a bottle shaped all sorts of different ways. Doesn't have to have functionality related to the shape. Okay? There's also plant patents. These are specific to certain types of engineered plants. I've never actually come across one. They're pretty rare, but just putting it there so you know that there's technically a separate type of patent. So, what are the requirements for a typical patent in the United States? There's two primary issues that you have to, or hurdles that you have to overcome to obtain a patent. The first is you have to demonstrate that the invention that you're claiming is novel, okay? Meaning it's never existed before. No one's thought of it before you did. All right? The second prong here, and this is the hardest to overcome with the patent office when you're trying to convince the patent office that you have a patentable invention, is that the patent needs to be non-obvious to a person reasonably skilled in that field of art. Okay? So if you're talking about a drug, a new drug compound, you know, would a pharmacist or a PhD in chemistry, they would be someone skilled in the art, would they deem what you have invented to be non-obvious? And usually what happens when you determine whether or not something is non-obvious, what the patent office does is they look at what's already out in the prior art, okay? Meaning before you filed your patent application. And they look at all the publications through the entire world, right? And see if they can find what you did, see if it already existed. And many times, you're able to overcome novelty. They can't find any specific reference publication out there that teaches exactly what you do. Okay, if they do, then you probably didn't do your homework before applying. You should have known that something wasn't exactly out there already. Hopefully you don't run across novelty. But what often will happen is that the patent office examiner, when they're reviewing this, they'll say, okay, well, your invention has 4 features, A, B, C, and D. I found this reference over here before you filed your application that shows features A, B, and C, but it really doesn't have feature D in it, okay? A second reference which is similar to what you're doing, teaches element D. And then the patent office will say it would have been obvious to a person skilled in this technical field to read both of these documents, these publications, and arrive at your claimed invention. All right, so that's kind of how obviousness works. And then the patent attorney's job is to, from a legal basis, argue why the examiner is off his rocker. All right, so moving on from that, what are the rights in a patent application or from a patent? It is an exclusive right. Okay, it's an exclusive right to stop others from using, making, having made, or offering to sell, or selling, or importing whatever it is that you've claimed. Okay? Understanding that it's an exclusive right is absolutely key. Okay? It is not a permission to do whatever it is that you've invented. All right? That is a completely different analysis. To explain how you can get a patent on something yet not be able to practice your invention, I have an example for you. Let's say person A invents a doorknob. Okay? You can open and close doors by turning the doorknob, and the latch comes open. It makes it easy to open and shut doors. Fantastic. He gets a patent because no one had ever made a doorknob before. Right? So he claims a doorknob. Person B sees the doorknobs on the market and says, that's really cool. But you know what would be even cooler is if someone put a push-button lock in the middle of that doorknob. Okay? That person B, files for a patent on a doorknob with a push-button lock in the center. All right? It's an improvement. It's deemed a non-obvious improvement over the original doorknob. Okay? Patent office says, you are granted a patent for that. Great. Person B gets a patent for making, or that excludes others from making doorknobs with push-button locks. However, person B cannot make a doorknob with a push-button lock because person A holds a patent to just doorknobs. Doesn't matter what else is in there. If it's a doorknob, it's covered by the first patent. Okay? So what ends up happening is you get this thicket, if you will, of patents that will issue because people are getting patents related to improvements of existing technologies. A lot of times because they're learning from the knowledge base. Just as I said, this is what we want to do. And then what happens is each holder has these different rights, and they oftentimes will get together and create contractual relationships where one gets the right to license the other person's patent, or maybe a third person steps in and acquires both patents so that they control both of them. Whatever it is, the abilities of one to control the other force parties to get together, make business deals, and hopefully move to bigger and brighter places. How long do patents last? They last 20 years. Well, for a utility patent, a standard utility patent, lasts for 20 years from the day you file, from the day that you file your application. Okay? It's enforceable from the period of when the patent application issues. Okay? The average time for a patent to issue in the United States is about 3 years. Okay? And that's really, really fast on a global level. If you think about it from the average, you file your application, it sits in the queue in the patent office, you wait for a little while, and about 3 years later the patent office says, yeah, you've got something here, we'll issue it as a patent. You now have approximately 17 years left that you can enjoy the right to exclude others to make what and sell what you've claimed. Design patent lasts for 14 years from the day it issues. Okay, it's not calculated from when you file it. It's calculated as just a flat 14 years from when it issues. Sometimes, depending on the subject matter that the invention is related to, it can take a very long time. There's also other things that can occur depending on what the invention is. For example, if you are inventing a pharmaceutical and you have federal regulatory processes to overcome, there are ways to recapture some of the lost time in that 20-year period if it's not your fault. Like, you know, if the FDA is just hanging on to this thing for way too long, you can recapture some of that time over. But in general, you should think of it as from 20 years from when you file. Okay. Things that can be patented. I mentioned these before: processes, machines, methods of manufacture, compositions of matter, and any kind of new and useful improvements of the same. The key here, there are some things that are excluded from what's patentable, and we've been seeing a lot of that lately. Let's see here. Yeah, here it is. Things that are not patentable, okay, are just raw ideas. Okay, you cannot patent an abstract idea. Okay, you can't patent a mathematical algorithm. Okay, things that are just that can theoretically be performed just in your head are not patentable because you can't own something in someone's head. All right? You can patent a abstract idea or a mathematical algorithm that is embedded in another product, okay, where a product or a process utilizes that abstract idea, okay, giving it some body to it, but you can't just patent the abstract idea on its own. The other thing that you can't patent are laws of nature or any kind of natural phenomena. Okay? You can't go back in the woods and find a compound and say, I patent this, right? What you can patent is an isolated, purified form of something that you found, okay? So in other words, you're taking it and you are manipulating it in some way first. That's patentable if it gets past all the other hurdles. Same thing with we're seeing it a lot in genetics. You can't patent the information in a DNA sequence, okay? But you can patent a plasmid. I don't know if any of you guys have biology backgrounds, but you could actually patent the chemical sequence that is cloned in a plasmid, all right? Or a cell that has been transfected with some kind of DNA that sequence that you found, all right? But again, you're putting some human manipulation into the information that is related to that genetic material, okay? Software is an area that has constantly been debated about whether software is patentable or not. I said that earlier that you can get a copyright for software. That's true. However, the protection in copyrights is very thin. It can be mildly useful to you, but what people would love to be able to get is a patent that relates to what the software is actually accomplishing. Okay? And you can do that. However, it gets a little tricky and you have to tie in features of the system, the overall, the hardware and the features that run the software in order to ultimately get claims to what the software itself is doing. Because software as a concept is considered an abstract idea. Okay? But you can do it. So how am I on time here? You know what? I think what I'm going to do is wrap up there for now and open things up for questions. And we'll see where questions go. If there's not too many, I can talk about a few other ideas here. Anyone have questions about any of these ideas? Yes?
Do U.S. patents not, like, are they not good over, like, in other countries and stuff?
They're not. They are not good over in other countries, similar to the way trademarks are only protected in this country. If you want to get patent protection in other countries, you have to ultimately file patent applications in those other countries. Okay? This actually brings up a really good point related to patents that's not in these slides. The rest of the world, other than the United States, has a system of what they call absolute novelty. Okay? Meaning if anyone discloses your invention anywhere, including yourself, if you make a public disclosure of that invention, you have lost your ability to obtain patent rights in pretty much every country that you care about other than the United States. All right, so if you have and this happens all the time in academic institutions, for example. Professor and their postdocs are creating some fantastic inventions in their lab. They tell their tech transfer office, you know, I think this is worth patenting, and then the tech transfer office says, yeah, it is. That sounds great. You know, we'll get an arrangement together here. Meantime, the postdoc is trying to you know, make his way for his own career, and takes that subject matter of the invention and goes and presents it at a conference in a poster session or something like that. Okay? That's a public disclosure of the invention, and that postdoc just blew the rights for himself and his PI to protect that invention potentially in other countries. Okay? So absolute novelty is the general rule for everywhere outside of the United States. In the United States, you get 1 year from the day you publicly disclose your own invention to procure a patent for it. So if this same thing happens, the postdoc goes and presents a poster showing everything at the conference, they could still file a patent in the United States as long as they do it within 1 year of when they made that public disclosure. Okay? Yes?
Could you talk a little bit about provisional patent and the role that has in that context?
Oh, sure. So in addition to, you know, I mentioned utility applications, design patents, and plant patents. There is what falls under the utility patent application, there is something called a provisional filing. Okay? A provisional filing is really it's like a placeholder. Okay, you file it in the United States. It doesn't have the same formalities as a standard utility application for purposes of what has to be in it. But what it does is it allows you to set with the patent office, you know, basically your stamp in time. I thought of all of this, whatever is in your provisional application, as of the time I filed it. Okay? And it will reserve it. The patent office is not going to examine it. It'll just sit there, and then you have up to 1 year to file a formal, regular utility application. So what often happens is if something gets in a rush, like either you're about to make a public disclosure and you don't have time to prepare a formal patent application, or maybe you don't have the funds to do it right then and you want to do something a little bit easier, you can just take whatever materials you have that best describe your invention and file it as a provisional application. Okay? There's also something called a PCT application. That stands for the Patent Cooperation Treaty. This is something that you can file with the Patent and Trademark Office in the United States, but it actually acts as a international patent placeholder. Okay, think of it, if you think about the rest of the world as a big wheel, the PCT is like the hub in the center. You can file your PCT application, and then it gives you basically a delay of another 18 months or so, in which time you can decide where you want to actually file in each and every country. Filing patent applications is not cheap. Okay, preparing and filing in the United States can range anywhere from $5,000 to $20,000. Okay, that includes your patent attorney fees and the filing fees with the government. Depends on how complicated the subject matter is. And then in other countries, it can be even more expensive, especially in Europe. The European patent process is incredibly expensive. But just to, as an example, if you want to pursue patenting an invention in just the major areas of the United States, the European Union, Japan, Canada, and Australia, let's say, right? You're easily going to drop $50,000 to $60,000, right? Just to have a chance of getting a patent in any of those countries. So the PCT is nice because what it does is it allows you to delay that decision-making process. Hopefully your business will evolve and go through enough that you can say, okay, I now know more targeted, these are the countries I care about for patent protection, and I can budget these, however you can through it. Okay? Any other questions? Yes?
It's my perception that pharmaceutical products overwhelm the system. Is that correct?
I don't think that's true anymore. I think that was true at a time. I would say that software and business method applications now overwhelm the patent office more than anything else. Pharmaceuticals require a certain level of experimentation to occur before you file it. It's deemed an unpredictable art. If you just say, oh, I have a compound and it cures cancer, right? The patent office is going to say, prove it. Just because you said it doesn't mean that you did it, right? But if you look at some of the mechanical and electrical arts, those things are deemed predictable. You know how circuits work and how electrons flow and all of that kind of stuff. Same thing with software. You can actually come up with what the software is going to look like and do in a predictable way prior to actually having written it. So people are able to stimulate their ideas and draft applications even before proof of concept has genuinely occurred, as long as what they can describe actually can be done. That's another thing too. There's sort of a misconception with patents that you have to actually have a prototype in order to file a patent application. It's not true. Okay, you do not have to have gone through a prototyping to file a patent application. All you have to do is be able to adequately describe and enable whatever it is that you did. If you can do that with your drawings, conceptual drawings, and give enough description so that if someone were to do what you say and it works, good enough. You don't have to actually make the prototype first. Any other questions? Oh yeah.
Could you talk a little bit more about the Madrid Protocol?
The Madrid Protocol is, it's in trademarks, and it is a way of trying to make international trademark filing a little bit cheaper and easier. Okay? So, I mentioned for patents, there's the Patent Cooperation Treaty. In trademarks, it's the Madrid Protocol. And what it does is it's a way of centralizing an application where you are then designating which countries you want to later validate in. So it's really just, if you know when you're filing your trademark, you know you're going to want a lot of different countries, the Madrid Protocol can make that process much simpler. And in some cases cheaper. If you're only talking about a handful of countries, like 5 or less, it's probably not worth it time and money-wise. But if it's a large number and you know that up front. Something to note here too with trademarks, I said in patents, you have to file applications and pursue protection of those rights prior to their public disclosure. Okay, that's not true in trademarks. If you have a trade name or something, or a symbol or whatever it is that you want to use, you don't have to go protect that first. You don't have to file in every country first. You can actually do it later. You can pursue in the United States, and as your business grows, you can then file it later in other countries. Okay? Now, you obviously want to get into those other countries before someone else thinks it's worthwhile trying to rip off your brand. Okay? So you do need to be proactive about it, but there isn't a sense of novelty where, so you made that mark public and therefore you can't do it. Okay? Yes?
How much more protection does a registered trademark have over an unregistered trademark?
So an unregistered trademark is really only going to protect you for your actual use, as long as you've been using it first, in a market in which people might be confused. Okay, so if you're, Joe's Hamburgers in Pennsylvania and you never bothered to file a trademark for it, and someone out in California opens up a Joe's Hamburgers shop, you're not going to be able to stop them from using that based on just, your actual use and your unregistered trademark. Okay? It might help you for purposes of someone setting up Joe's Hamburgers on the corner next to you, right? Because there's some local confusion going on who's who, but it'll be more on a geographically localized. There's issues that come up with that when you're using marks over the internet, and it's a can of worms I'm not going to get into here for how common law would work in that instance. But filing a trademark is very simple, and it's really for people who are savvy and willing to spend a little time educating themselves. You could do it on your own. You could file it on your own without the need of expensive lawyer fees. So it's worth looking into. However, even that, because of that, when you do get an attorney to do it, it often isn't too bad. But it's still, it's still extra. Anyway, trademarking on a federal level is not hard, and it's worth looking into as the initial way to go, as opposed to just waiting and seeing whether you're successful or not first. It's only a couple of $100. Any other questions about any of this stuff? No. I think one thing I'll just mention real quickly here. I talked about patents being an exclusive right, and it doesn't give you a permission to do anything, right? You need to think about whenever you're starting your business and you are going to enter the marketplace either with your product or your service, or maybe you're going to utilize some methodology in the process of getting to your marketable products. You need to do two things when you're analyzing your own technology. One, is it patentable? All right, that's what we've been talking about here. Is something out there that already teaches what you've done. Okay, that will determine whether or not you can get your own patent, right? And have exclusive rights. The other thing is the other question you have to ask yourself is, do I have freedom to operate in what I'm actually doing? Okay, outside of whether I can get a patent for my own inventions, do I have freedom to operate in what I want to do? Okay, that analysis looks at third-party patents, issued patents, and determining what those patents exclude others. So you have to have an analysis of your business and say, if I go out here and do this, and sell this product, is someone going to hit me with a patent infringement suit? Because you should know that before you start spending money, in that process. So it's two things. You want to see whether you have patentability, and the other one is you want to know whether you have freedom to operate in your business. Okay? Any patent attorney can help you with that, but remember the distinctions because they're genuinely different. All right? I think that's it.
Okay. Thank you, Mr. And I think there's a group that's going to take you to lunch.